Hello, good afternoon, Amir.
Hi, good afternoon.
So, intellectual properties, IP issues in going global. This is a flexible online training, and I'd like to thank CAS for making this happen. Okay, and I read the introduction. Okay, so now more and more local businesses are venturing into foreign markets, and the world becomes flatter thanks to cheap air travel. You all can see, right? This write up. Are you able to see that? Can Okay. Thanks to cheap air travel, internet access, increased global awareness among businessmen, and so on. As various issues crop up in terms of the use, protection, and translation of local brands in the midst of such expansion, we'll take a look at the problems and hiccups a local brand will face abroad, and also strategies to preempt and avoid the problems, together with tips to overcome the challenges of going global. So in this webinar, you will learn about the problems and hiccups local brands face when venturing into foreign markets. You will also discover strategies to preempt and avoid the problem mentioned, and obtain valuable tips on how to overcome the challenges of going global. So sitting our master trainer today together with us is Amir. He's the trademark and design executive from CAS International. So he handles the searches, registration, and prosecution of trademark and industrial design applications, and advises on issues pertaining to the same. So before joining CAS, Amir worked with a major telecommunication firm, and then he complements the trademark and industrial design team at CAS, using his past experience to his advantage when dealing with clients from diverse backgrounds. So his professional expertise includes trademark, copyright, industrial design. So without further ado, let's put our hands together to welcome Amir. So are you all ready for Amir to share? If you are ready, type in the chat box R for ready. Type in the chat box R. Type in the chat box R if you are ready. Then Amir will start sharing. The floor is yours. Type in the chat box R if you're ready.
All right, thanks, Ivana. Greetings to everyone, no matter where you are listening to this webinar from. And to those who's listening from Malaysia, hope you had a great lunch. And we sincerely apologize for the delay just now. There was a technical problem on our side. All right, my name is Amir Murshidi. I'm a trademark and design executive at CAS International, and I've been in this field for 6 years. So more and more businesses are venturing into the foreign market. Of course, there are various issues arise from different angles. And today we'll be discussing on one of the issue, that is on the intellectual property issues in going global. Well, I guess some of you may have knew what intellectual property means. Intellectual property is a creation of minds. It's a human's creativity that consists of various of elements such as music, arts, names, symbols, innovations, designs, and many more. All these are part of the is a component of the intellectual property. So by the end of this webinar, you will know what are the common issues you will face in the foreign market, the challenges, strategies to overcome the problems, and how to maintain your rights in the foreign market. And that include things you should do before venturing your business in the foreign country, as well as things that you should do while in business in the foreign market. So why do the intellectual property important? This is actually an asset, an element that differentiates you from the other traders. We at CAS, we have been in this field for 19 years, and based off our experience throughout the year, today I'm going to highlight three fundamental issues in going abroad, and they are compliance with laws of the foreign country, as so-called as the regulatory approval, ensuring you are not infringing rights of others in that country, and claiming monopolistic rights in that country. All right, let's look at the first issue on the list. Ensure that you, as entrepreneurs, you've got the regulatory approvals. Bear in mind that every country has different rules and regulations, so do study them or get advice from the experts before you start your business abroad. For example, this is a checklist that you can use to ensure that you adhere to the laws of the foreign country. And of course, this checklist will depend on the product that you manufacture in the foreign country, that include marketing approval from Drug Control Authority, approval from Ministry of Agriculture, approval under Medical Devices Act, compliance with national standards, and comply with the Food Act. As for the second issue, how to ensure that you are not infringing rights of others in that country? Well, this is the answer, and this is what you need to do. It's through a marketing clearance. You should obtain a clear freedom to operate FTO or market opinion or trademark clearance search before you start doing your business in the foreign country. We don't want other party to take action against you later on. And the freedom to operate is to ensure that your products do not infringe a third party's patent in that foreign country. And the trademark clearance search is for you, for your brand or for your name that you use on your product. And how to get the report? Best to engage a professional firm to do it for you. And the report is very important as you will know what's already in the market. You will know if the same products exist in the market. You will know whether your products infringe a third party's patent. And you can also preempt issues or complications you may face in that country and avoid you from wasting money on unnecessary things later. Should you got a negative report, you can always go back to drawing board, brainstorm, and come up with a new idea or rebrand your product. This is safer rather than you taking a risk of manufacturing or rather than you taking a risk of exporting your products without knowing what's already there in the foreign market. Do also conduct clearance searches according to your products, according to your goods or services you offer, not only focusing on the physical part of the product, but also on the name you use on the product. In conducting the clearance search, do consider a linguistic check to ensure that the name you use on your product does not carry any negative connotation or contradict to the local sensitivity or against the public morality. Well, speaking on this linguistic check, what kind of cultural or language barriers will one face then? And what type of trademark strategies should one embark on? Let's look at our first case study here. It's about a businessman who entered a new market with a new product, but market responded poorly. Malaysians call this as lip Barbie. Lip Barbie is a brand for cosmetics and that including lipsticks, which was filed by US company as a trademark in Malaysia. It meant to be called as a lip baby. And for those who doesn't know, lip Malay language mean pig, where 60% of our populations are Muslims. Use of the word of the trademark or the brand Lee Barbie on the products will not be a good idea as Muslims will not buy the product anyway. And I think based on this reason, the owner, this US company, did not maintain its trademark registration and the brand is no longer active in the register. So, how to avoid such obstacles in future? And that is why it is vital for you to ensure that the clearance stage that you have conducted include linguistic checks as well. I'm going to show you some other examples of trademark filed in other countries or filed by a foreign applicant which carry a negative connotation. Taking the word palat, for example, that was filed, it was meant to be filed for electrical devices and it meant sheet of pieces in the Malay language. Boon is for sources, it should be filed in the United Kingdom. Pinto actually for cars. Jetebra, this is actually one of the IKEA's product. It should be for pot and redundant for bed. As the words, all these words carry negative connotation in the local languages of that country. So the brand owners have to rebrand the mark. Let's look at another real life example. This is a car. Anybody can guess what car is this? Maybe you can write in the chat box if you know what car model is this. It's actually a model from Tata Motors, and this is the initial name of the car. I think everyone knows what Zika means, right? Tata Motors was unfortunate that they were just about to launch the model, and at the same time, the Zika virus became epidemic. And guess what? They rebranded their car to, and how they went about the rebranding exercise. Here you go. It's Tiago. From Zika, they have rebranded the car model to Tiago. The new brand was selected from 37,000 entries data received through social media and SMS in a campaign they carried out globally. And the price was the car itself. Imagine if they maintain the brand or the name of the car model to Zika. Would people or would you buy a virus car? So based on this lead, Barbie, and Zika example, it shows that why a clearance search is very important before you start exporting your products abroad. Right, we have to look at the clear freedom to operate or trademark clearance searches now. Another important thing that you need to do to ensure that your products are hassle-free and to ensure your products are in compliance under the labeling regulations under different acts such as Pharmaceutical and Cosmetics Regulations, Poison Act, and Food Act. And last but not least, ensure you comply the Trade Description Act. Basically, the main concern of the Trade Description Act is to protect consumers from unhealthy trading activity. And the Trade Description Act is an act for the purpose of promoting good trade practices by prohibiting false trade description and false or misleading statements, conduct, and practices in relation to supply of goods and services. All right, we now move on to the third issue on the list when you are venturing your business in the foreign market. It is in regards to claiming exclusivity. We're going to explore on how to get monopolistic rights in the foreign market. And firstly, by way of patent registration. If you still remember at the beginning, I said that patent is a component of the intellectual property. But what does patent means? Patent refers to product or process of manufacture, use of a product that provide a new technical solution to a problem. It can also be a new method of doing things, the composition of a new product, or a technical improvement on how certain objects work. So based on the patents meaning just now, do identify your product and get an exclusive patent rights if eligible. Now, why did I say if eligible? This is because to obtain a patent registration, you must meet three main criteria, which are novel or new. That means the invention is new and has not been publicly disclosed in any form anywhere in the world. And the patent must be inventive. The invention must not be obvious to someone with knowledge and experience in the technological field of the invention, and it also must be industrially applicable. Secondly, get the monopolistic rights in the foreign country by way of industrial design registration. Industrial design refers to the shape, ornamental features of a product or packaging. They are new or novel, appeal to the eye, and also it must be industrially applicable. Further, it must be noted that industrial design only protects the external appearance of the article and not to its functions. That is to say that the industrial design should not be dictated solely by its function. Thirdly, claiming your exclusivity by way of trademark registration. This is one of the easiest one to do. Trademark refers to identifier of source of product that distinguishes your goods or services from that of other traders. It's the brand, the name, the word, phrase, symbol, or logo that you use to represent your products and services. So now you have understood what is patent, what is trademark, and what is industrial designs. Now let's look at some example of intellectual property rights that exist in packaging products can get patent rights. For example, I can give here package to hold potato chips that owned by the McDonald's, and also pull tabs on the beverage can. And these are examples of intellectual property rights in the furniture. That is, you can obtain or claiming the exclusivity under the industrial design rights. And these are examples from industrial designs that's being registered in Malaysia. Also, the intellectual property rights in products, that means to the trademarks, the brands that you use to represent your products. Look at P&G, Unilever, Nestle. These are actually examples of house brand, and there are product brands under this house brand. Taking Unilever, for example, its product brands include Dove, No, Lifebuoy, Lipton, Lux, Rexona, and many more. P&G, there are quite a number of product brands as well, such as MB Pure, Downy, Febreze, Gillette, Head and Shoulders, and many more. Having said that, there are also many local brands that are popular in other countries. Look at these as examples. The Life Source, for example, is manufactured 26 million bottles per year, and it is exported to the UK, US, France, Australia, and New Zealand. Munchies is exported to more than 50 countries. Mummy Monster, it is exported to more than 80 countries. These local companies have proved that they've made it, and I believe you can do it as well and be success as they did. Speaking on local brands going global, let's look at other challenges that you as a brand owner may face in the foreign country. I'm going to show you a case law that happened in China, a case between Starbucks and a Shanghai coffee house, that is Shanghai Zingbaker Coffee. It was a famous case as well. And the lawsuit was filed in 2003, came as a result of Shanghai Zingbaker's use of Starbucks Chinese name, that is the Zingbaker, in its company name. In Chinese, Zing means star, and Barker, pronounced as Barker, is a phonetic rendition of bucks. So Starbucks sued Shanghai's Zingbaker for appropriating Starbucks font and its famous green and white circular logo, as well as imitating Starbucks design motif for its coffee houses. However, the Chinese company Shanghai Zingbaker claimed that it had the right to use the Chinese name Zingbaker because it had registered its company under this name in the city in 1999, and that is before the Starbucks company. But the court found that Starbucks had precedent in the Chinese market because it had registered its Chinese name in China in 1998 and had also registered the Starbucks font and logo during the period. Moreover, the Starbucks logo was recognized worldwide, and the Chinese name Zingbaker was also recognized among the Chinese-speaking communities, making it a well-known trademark. And as a result, the court ruled that Starbucks was entitled to sole right to use its name in both the English and the Chinese language. All right, from this famous case, what you need to know about entering a China market? The court in China adopted the first to file principle as opposed to the first to use principle. That means those who is first to file the trademark application in China would have better rights than those who first to use the trademark in China. Another key point that you can learn from this case is that when registering your trademark overseas, do consider local language script nicknames as well. Example of marks used in China, Ferrero Rocher, for example, there are two registered in the Chinese version of the mark. Here are some more examples: Coca-Cola, Fanta, Kit Kat, the Double Mint. They do register in both languages. Now, why do they register in the local language as well? This is because the locals speak their language first. Even some of the brands are represented in both language. So if you are exporting your product to Myanmar, for example, do consider to register your brand in the Burmese language as well. So this is actually one of the strategy you can apply on when exporting your products in the foreign market. All right, in the previous slides, we've learned what is the intellectual property and examples of what intellectual property will you have in packaging products, in furniture, and some trademarks or brands on the products. So let's try this one. Let's say you are exporting handbags to other countries. So what intellectual property do you have in handbags? And what element you should protect your intellectual properties under? Generally, handbags may entitle for industrial designs and trademark rights. And I have an example for this one. I'm pretty sure Malaysians know very well these bags and the brand. Yes, they are the Hermes Birkin. Birkin was named after the famous singer and actress Jane Birkin. Well, Birkin used to be a trending topic before, especially by the Malaysians, and they say that the price of this bag is equivalent to buying of 5 luxury condos. Wow. Um, well, I think I better make it clear here that I have no intention to imitate anybody. This example is merely for trading purposes only and nothing to do with anyone, so don't get me wrong. Like, come back here. So, what intellectual property do they have here? The brands, Hermes and Birkin, they have protected the names as trademark and also the design, the shape of the handbags. This they're protected under the industrial designs right. And these are some examples of the industrial designs that Hermes company registered in Malaysia. So do identify your intellectual property on what intellectual property your product has and protect them in the foreign country as well. Well, I believe you now have a clear picture on what are patents, what are trademarks, and what are the industrial designs. The question is, why do we need to obtain the exclusive rights on this? By the end of this webinar, you will know why. So do stay tuned and don't go anywhere. To go deeper on the exclusive rights or the monopolistic rights on the intellectual property, I'm going to show you a scenario in a fast-growing and a very profitable industry. That is in the pharmaceutical drugs industry. We'll be looking at how people that are involved in this industry obtain the market exclusivity. We're going to look at the patent, trademarks, and also the copyrights. Did you guys know that according to a statistic in 2006, global expenditure on drugs was over 643 billion in the United States of America? The pharmaceutical industry has been the most profitable one for many years. A famous example that I can give here is this. It's Viagra drugs. Viagra is manufactured by Pfizer, a company from the US, and is one of the biggest in the world. I think everyone knows what Viagra means, right? Also known as the blue pills. So today we will look at how Pfizer uses the market exclusivity on Viagra. In Viagra drug, there are various elements that can be protected and registered, such as the patent. Pfizer protected the active ingredient and the composition of the drug, as well as the process of manufacturing the Viagra drug. They also protected the drug or the products under the industrial design rights. It's the diamond shape of the pill, and the diamond shape is not a common shape for pills. And of course, they protected the name, the Viagra brand, under the trademark registration, and also the color of the pill. Color can also be registered as a trademark, also known as the non-conventional trademark, but it's only applicable in certain countries such as the United States of America. And also they're protected under the copyright. Copyright refers to the expression to creative works, artistic works, literary works, musical, films, sound recordings, broadcast, and derivative works. And for this Viagra drug, the copyright exists in its instructions booklet or manual. So Pfizer had filed all these intellectual property elements to get the monopolistic rights so that other companies could not produce, so that other companies could not manufacture the same product, the same drug as theirs. And by monopolizing and controlling the market, Pfizer, of course, can charge expensive price on their drugs. And that is how they made the money. For record, on its first year, Viagra sales revenue had reached over 1 million US dollar. Actually, what Pfizer had done was a brilliant business strategy. Why? It's because its patented drug will eventually expire. Its registered industrial design will also eventually expire. However, its trademark registrations will last forever. Just to let you know that patent has maximum protection of up to 20 years and it is non-extendable. Industrial design, it's valid up to 25 years. Trademark is for 10 years, but it is renewable, so the trademark will last so long as you keep renewing your trademarks in that country. And for copyright, you get the protection from the life of the author plus 50 years from the date of first publication. The origin of Viagra came from the drug sildenafil citrate, and initially the drug was studied upon to treat hypertension and chest pain due to heart disease. The first ever clinical trials conducted showed that it didn't have much effect on the heart disease or the chest pain. Rather, it could induce remarkable penile erections. Pfizer thus decided to market and promote the drug for erectile dysfunction. Although Pfizer had registered all its intellectual property elements and that being part of its business strategy, there's still challenges and issues they have to face in the foreign market. Looking at the duration of patent and industrial design, once the patented Viagra drug has expired or once the registered industrial design of Viagra has expired, it will be free for the public to use it. That is to say that others may produce or manufacture the same formula or composition, and in this pharmaceutical drugs industry, it is known as the generic drugs and sell at much lower price. There was a case in 2010 where Pfizer sued a company from Israel. It is Teva Pharmaceutical Industries Limited, pursuant to Teva's plan of introducing a generic version of Viagra. However, after several negotiations and after an undisclosed agreement between them, Teva was authorized to produce the generic version of Viagra, and it was told that Teva has to pay royalty to Pfizer once the patent for Viagra drug expires. This is actually another example on how you can control the market and make profit from the monopolistic rights you have. This is another brilliant strategy by Pfizer in facing the issues in the international market. The intellectual property registrations provide you opportunity to license your rights to a third party and get passive income from the licensing fees. And that's what Pfizer had done. Another issue that Pfizer had to face in the foreign market is this. This is a case law in Indonesia where a person named Benny Dijaja, an Indonesian, had filed a trademark application for Viagra and it's for the same goods as Viagra. Pfizer took a court action against this Benny on the grounds of bad faith and that the Viagra mark was filed for a confusingly similar mark to a well-known mark, and Pfizer won the case. Pfizer wouldn't have knew on Viagra's existence if they didn't conduct surveillance periodically. So what we can learn from this case is that although we have protected our rights in the foreign countries, we also need to take initiative and be proactive in maintaining our exclusive rights abroad. Well, taking this Viagra drugs as example, even there will be generic drugs in the future which may be produced by other parties, but do consumers trust the other brands easily? This is where trademark or brand plays an important role as the consumers know very well the quality of the drugs based on its brand. Panadol, for instance, although there are many paracetamol brands in the market, people still prefer Panadol till now. The brand Panadol still stands out until today. Although the patented Panadol has expired a long time ago, its brand still alive and being the most trusted paracetamol brand in the world. So based on these examples, what you can do is to strategize and make use of your intellectual property assets wisely. Well, it is also important for you to know that intellectual property rights are granted by the government of each country. The rights given are territorial by nature. Doesn't mean that you register your intellectual property in Malaysia, you will get automatic protection in other countries, except for certain regions, such as in the European Union, where one registration offer you protection in all 27 countries, and also in the French-speaking African countries, you can apply a single registration through ORP system. Further, intellectual property rights have a fixed period of durations, as I shown earlier, and rights granted to foreigners must equal to rights granted to local businessmen. That is to say that no discrimination against foreigners under the Paris Convention, the TRIPS, or trade-related aspects of intellectual property agreement of the World Trade Organization. Also, intellectual property rights require positive action by the owners of the intellectual property. It doesn't mean that if you have registered your intellectual property, the police will take action against anybody who violates your rights in that country. The owners themselves must take initiatives such as administrative action by lodging a report with the relevant authority to conduct a raid or by initiate a civil action at the court. We now look at what will likely be happen if you not protect your intellectual property. Unless protected according to the law, there are no rights to stop others from using the invention, from using your innovation or industrial designs. Others can use your technology without your consent, and generally, other party will wait until you create the market, then there only they will introduce their product. And without protection, all risks and costs will be borne by you. The years of research and development costs also include initial market introduction costs as well as the regulatory approval expenditure. And your right will be taken advantage by the other parties as well. Well, we always come across this question. I've used the mark for so many years. Why do I need to register it? Don't tell me I have no right at all. Well, in some countries like Malaysia, yes, you still have the rights based on the first to use principle. However, in some other countries that practice the first to file principle, like China and Indonesia, where priority is given to those who first to file the mark in that country. Without registration, it's difficult for you to enforce your rights in the country. There are many reasons to have the intellectual property registered. For example, it will be much easier for you to take actions at the court by adducing the certificate of registrations. Without registration, you still can rely on common law thought of passing off, but you will need to adduce a lot of evidence to show that you have goodwill and reputation, to show that the misrepresentation by the other party to prove that you've suffered damages, either you've lost the profit or the other party has gained profit. In addition, trademark registration, for example, does not cover all goods or services. There are classes for each item based on the niche classification set by the World Intellectual Property Office. For example, clothing, footwear, headgear, this falls under class 25 of the trademark niche classification. Cosmetics falls under class 3. So if you register in class 25, you won't get a protection in other classes unless you register in other classes as well. Another reason as to why you need to register your intellectual property is, as mentioned before, the monopolistic rights are territorial by nature. Your registration in Malaysia does not extend your rights in the foreign country. Alright, so far we have understood what is the intellectual property, its duration, and also consequences of not protecting your intellectual property. Now, we're going to explore on how to maintain the exclusive rights in the foreign market. Things that the intellectual property owners should do are payment of annuity fees in respect of patents, payment of annuity fees in respect of industrial designs, as well as renewal of your trademark registrations in that country. Secondly, surveillance of market for intellectual property infringement activities by distributors or by independent investigation firm. And thirdly, you can take legal action against violators of your rights. I'm going to bring you to another case law in Malaysia. It was a long battle between McCurry Restaurant and also McDonald's Corporation. But the decision of the Court of Appeal was in favor of the McCurry Restaurant. I don't want to go depth on this case, but this is an example on what McDonald's did in order to maintain its exclusivity in the foreign market. McDonald's took the court actions against the McCurry restaurants as they thought that McCurry has passed off their business in Malaysia. Unfortunately, McDonald's couldn't stop McCurry from using the mark for their business. Another case that I would like to present today to show you a real-life case on what the intellectual property owner has to face in the foreign market is a case law in Malaysia as well. It's between McLaren International Limited and Lim Yat Min, a Malaysian individual. Well, Lim Yat Min had filed the trademark for McLaren in 1992 and registered it in respect of articles of clothing, and that should be under class 25, whereby McLaren International, on the other hand, only filed its trademark application in 1999, the time about Malaysia first hosted the first F1 race. And the McLaren International came to know of the earlier McLaren marks by Lim Yat Min when it was cited in an objection by the Registrar of Trademark in 2001. And that's where the case began. However, the court's decision was in favor of Lim Yat Min, the Malaysian individual. McLaren International couldn't register their mark in Malaysia due to existence of earlier mark by Lim Yat Min. As a result, McLaren couldn't stop the party from using its brand on his products in a foreign country. I'm not saying that Lim Yat Min purposely copied the McLaren mark, as if you read the judgment of the court, he averred that McLaren is a combination of Larry and McCann Erickson, and that's how he coined the mark and got McLaren. This case is actually an example of a scenario that you may face in the foreign country, especially when your brands or when your products become famous. There are people that would like to take advantage of your fame and reputation. Again, you as the IP owners, you must take initiative in protecting and enforcing your rights in other countries, especially in countries where they adopt the first to file principle. In the process of exporting your products abroad, you must have been liaising with many parties. And for this reason, it is important for you to know to have a proper agreement either with distributors, agents, joint venture partners, and many more. Do also clearly mention in your intellectual that your intellectual property rights and never allow use of trademark as a name of business or company by distributors, by the agents, third parties, and many more. All right, let's take one last scenario here. Since now it's the durian season in Malaysia and it's one of the most favorite fruit by the Malaysians, let's look at durian scenario here. Let's say Ivana has a new idea of inventing a new tool to open the durian or to peel the durian skin easily in just a very simple step like 1, 2, 3, without a hassle and without causing an injury. But Ivana has no machine and she's not expert in manufacturing the tool. So she has to speak to the manufacturer and the factory people that can make and customize the tool for her. Therefore, in order to avoid Ivana's idea from being stolen, she needs to have an agreement such as a non-disclosure agreement with the relevant parties that she liaised with. Or else, the other people can copy her ideas and what will happen to Ivana then if someone copy her ideas? She will cry, of course. No, I'm just kidding. All right. Apart from the non-disclosure agreement, you can also have a licensing agreement with the relevant party and get royalty through licensing fees. And this will depend on how you draft the terms in the agreement. There are parties that might be interested to join your business later on. Therefore, make sure you have a well-drafted agreement with them. And this actually can be a passive income for you. And at the same time, you can control the quality of your products. Another example that I can give is one of our clients that sell clothing, but not accessory, not belts, shoes, and so on. And when the brand became famous, a third party approached him for permission to sell accessory under his brand. And that was an opportunity to have a licensing agreement with that party. He was not selling other products, yet he could still get additional income through the licensing. And nevertheless, you also need to take into consideration if the broader scope of your goods or product is really good to your reputation and business. Well, based on all examples, all the cases and scenarios I've presented today, I can say that intellectual property acts as a weapon in the battle to get a place in the international market. This weapon is used to stop competitors and to defend yourself if being attacked. And for that reason, your weapon must be strong enough to withstand any attack. Well, we've come to the last part of our session today. So these are some practical tips that you can use when venturing your business abroad. You can register your intellectual property rights such as trademarks in the name of the manufacturer or the exporter and do not allow the importer or distributor to register the intellectual property rights under his name or under his business. Can also periodically conduct surveillance in the foreign market to ensure non-violation of rights by third parties, and conduct a search on the trademark register in the foreign country to ensure trademark is not applied for or registered by a third party. And for this, you can engage an investigator to conduct a market survey for you. That is to ensure the quality of your products or services is maintained even in the foreign country, and to retain the customer's trust on your brands or your product. Can also be done by conducting a watching service, and you may file an opposition if needed. So in summary, what I can say that you just be aware of your intellectual property rights. You should know what rights you should obtain on your products or services of your inventions. Do also be aware of third parties' rights. And of course, do protect your intellectual property rights abroad. So, in summary, what we have learned today are what is the intellectual property? We know what are patents, what are trademarks, what are industrial designs, and also copyrights. We look at issues that you will face in the foreign market or the challenges you may face as well, strategies to overcome the problem in the foreign countries, how to maintain your rights in the foreign market, and also we look at examples, scenarios, and cases that happen in the actual marketplace. So with that, I think that's all my presentation for this webinar today. Hope you all benefit some or learn some things from this webinar. And with that, I pass back the session to you, Ivana.
Okay. So thank you, Amir. Thank you, everyone. And thank you, the IT and also Diana, who is like supporting us in the background. Thank you very much, Amir. Thank you,
Welcome.
everyone. Bye. Bye bye.